Hey guys, this is VJ Dinakar. In this video, I want to talk about how to fight against a domestic violence restraining order in California. So this video only covers California law, and I'm only going to be able to very superficially cover all of these topics. I am going to be making future videos in more detail about each of these subtopics. So why would you want to fight a domestic violence restraining order if you're served a copy and you're the restrained party? You might ask, you know what, I don't want to have anything to do with that person. I don't care if there's a restraining order against me. I'm not going to even fight against it. That would probably in most instances be a bad idea, because the restraining order that you're going to have put against you is going to be in the California law enforcement and telecommunications system, or CLET system. It might turn up in a background check, which can affect jobs. And if you have a child in common with the protected party who filed a restraining order against you, pursuant to Family Code Section 3044, the restraining order can have irreversible damage in terms of getting legal custody over your child. So there's many reasons you might want to file a response or your own restraining order against this person, and certainly fight the restraining order against you. Now, that raises the second question, which is, should you hire an attorney to help you in this restraining order case? You certainly don't have to, and I would say if you were to go to family court and see all of the restraining order hearings that are taking place, a lot of them do not involve an attorney on either side. So someone files a domestic violence restraining order against, let's say, their spouse or former spouse or boyfriend or girlfriend, and they're often not represented by an attorney, the person filing the restraining order, and also the person, the respondent, is also not represented by an attorney. However, I really think that is a mistake. If you can afford to hire an attorney, especially if you're the respondent, in other words, the person against whom the restraining order is filed, you really should hire an attorney. Additionally, if, for instance, this restraining order comes after you are arrested, which happens a lot, and I see this all the time. So somebody is arrested for domestic violence, the police are called, they're arrested, and then after that, a few days after that, the alleged victim, their husband or boyfriend or girlfriend or former spouse or current spouse, files a domestic violence restraining order against them in court, and they receive a copy of that. Now, their first instinct, because attached to a copy of that is at the form to respond, might be to write a response and say, this is entirely false, I didn't do anything, or this happened. That would be a horrendous mistake, because anything you say can be used against you in that response. And really, if you've been arrested, you really should not be representing you in the domestic violence restraining order case without an attorney. If you hire an attorney and after the restraining order is filed and you actually go to court and there is a contested trial and you win, meaning you're the prevailing party, your attorney might end up being paid for by the other party. And I've seen that happen many times. So it's, in all cases, when you can hire an attorney, certainly worth hiring an attorney, because the area of domestic violence law is actually quite complicated. Certainly the evidence code applies to all trials, but additionally there's all kinds of requirements that the court is going to expect you to basically comply with in terms of filing trial briefs, pretrial motions, even potentially discovery. That if you don't have an attorney, you really are at a disadvantage. Again, if the other party doesn't have an attorney, then in a sense, I guess you're at an equal disadvantage. But if the other party has an attorney, you really, I would say, almost have no chance. Now, with respect to the process of the domestic violence restraining order, so again, the person files a domestic violence restraining order against you, a request with the court. That court, let's say, reads the declaration about the alleged abuse, and they find that there's sufficient evidence to grant a temporary restraining order. And a temporary restraining order is granted for approximately 3 weeks, and there's a hearing set in 3 weeks. Okay, now at that hearing, there could be a contested hearing, although the court's probably not going to have a long time to do that contested hearing, typically only a few minutes. So what you are entitled to do in all cases, even if you don't have an attorney, is to request a continuance to prepare, or to request a continuance to have a longer trial. So in most counties around here in the Bay Area, at the first hearing, you're probably only going to have perhaps a 15-minute hearing if you want to do a contested hearing at the first hearing. So if you want to have a real trial, which quite frankly, if you want to win, you want to have a real trial, you're going to have to ask the court for a long cause hearing, which the court will not have available on that date. You'll have to schedule a trial on that date. And before the scheduled trial, you're going to have to make a decision in terms of what evidence you have to present the court. So evidence can be text messages, photos, videos, audio, emails. All those kinds of pieces of evidence need to be gathered by you and your attorney to get ready for this contested hearing. And by the way, just to rewind a little bit, the initial question you and your attorney have to answer is, should you file a response? So that's a DV-120 form in writing. There are some benefits of doing that, especially when potentially there's a child involved. You might want to definitely file a response because you might want to have some time with the child after the first court date. But there's some definite downsides of doing so, because if you're going to have a trial, in the response, you have to be careful about what you're necessarily disclosing to the other side, rather than basically keeping that evidence in a surprise fashion in terms of trial and winning that way. You also have to make a decision, and oftentimes this is the right decision, about whether in fact you should file, kind of as a response, your own restraining order. So a lot of times what I see happen is one of the two parties or both of the parties realize this marriage or relationship is going downhill. And so one of the parties essentially strikes first, and oftentimes that party is in fact the perpetrator of domestic violence, but they consult an attorney or they learn that it might be in their interest to file a restraining order for purposes related to custody or other reasons. And so they file first, even though they are in fact the actual perpetrator. So what do you do if you are actually a victim of domestic violence and somehow you receive a copy of a restraining order against you? Well, you are entitled, absolutely, file your own restraining order. So it might make more sense, depending on the circumstances of the case, that you would file, as opposed to a response, your own request for restraining order. And if the court reads that and grants that, then ultimately the court will combine the two requests for restraining order into one single trial. Okay, and that happens a lot. There are mutual restraining order requests, and then you're going to be going into a full-blown trial. There could be discovery. So that could include depositions where either you or the other party are required to sit down for an interview, essentially, which is transcribed by a court reporter, by the attorney, asking all kinds of questions. You may be subjected to written interrogatories where you're asked all kinds of questions. Again, this doesn't happen in every domestic violence case, but if you're really trying to win, and all the cases I handle for domestic violence restraining orders, I'm trying to win, you certainly want to do all of these things. Now, getting close to the trial, you want to file pretrial motions, which may exclude certain pieces of evidence that you don't want to be entered into evidence and heard by the judge. You may have to file a trial brief. You may have to submit your exhibit list, witness list, and eventually your exhibits to the court. With regard to witnesses, this is a super critical part of the case. You have to have your witnesses ready to go on the scheduled trial date. Those witnesses might be people who are your friends, your family members, and so they may not require, for instance, a court order to go. They're happy to go on their own, but it's probably best to actually issue them a subpoena just in case they, for instance, have work. Well, then they really can show that to their employer, meaning they have to go to court, and they really have no excuse not to go to court. Additionally, you may want to call police officers You may have had a previous encounter with the police where the other party against whom you're now filing a restraining order, or the person filed a restraining order against you, the police took statements from that person. So the police officer will not come without a subpoena. So again, I'm going to be making additional videos about all aspects of fighting the domestic violence restraining order against you, but this just gives you a very broad overview of the importance of doing so. If you guys have any questions about domestic violence restraining orders or any other questions, let me know. Take care and all the best.